Welcome to Employment Law This Week. I'm George Whipple. A study of the EEOC's controversial 2020 pay data collection has found that the data is a useful tool to fight pay discrimination in the workplace. According to the EEOC, which funded the study, the results show that pay data collection enables the agency to take a more data-driven approach to discrimination charges. The agency also said that the study encourages an expansion of pay data collection, though it is unclear what form that will take. Along with the wave of new pay disclosure laws, this is another reason for employers to review their pay practices in anticipation of possible future collection requirements. Restrictions on non-competes in Colorado take effect. Non-compete agreements executed in Colorado beginning today, August 10th, must follow strict new guidelines, or the employers that implement them may face heavy penalties. Non-competes are now banned in the state for any employees who are not highly compensated. The salary threshold is set slightly over 6 figures, with a lower salary threshold for non-solicitation agreements. Both thresholds will increase annually. The law also imposes significant notice provisions for such restrictive covenants to be enforceable. Colorado joins a growing trend across the country, along with a number of other states that have limited employers' ability to enforce non-compete provisions. And Washington, D.C.'s sweeping ban, which was recently narrowed but remains highly restrictive, goes into effect October 1st. Browning-Ferris heads back to the NLRB for the third time. In 2015, the board adopted a controversial indirect control standard for determining whether two entities would be held to be joint employers for purposes of the National Labor Relations Act. In 2020, a different NLRB majority, with Trump appointees, discarded the standard adopted in Browning-Ferris, holding that the Browning-Ferris standard would be manifestly unjust to employers. Now, the D.C. Circuit Court has refused to enforce that standard and has returned the case to the NLRB. It is anticipated that the Biden-appointed majority will once again use the Browning-Ferris case to advance a joint employer standard based on indirect control. The board may do this by either modifying the April 2020 joint employer rule, something the Biden board already has announced it intends to do, or, following the D.C. Circuit decision, the board could opt to simply rescind the prior rule and effectively replace it with a new joint employer decision on remand in the Browning-Ferris case. Stay tuned. And that's it for this week. Thank you very much for watching, and we'll see you next time.